Hello again, folks. So I was going back through the Denny motion, and this fucking greasy piece of shit. Oh my god. But today I wanted to break down some things that are not a part of the motion proper that was filed by Kratz. Now, okay, really quick, just so you guys understand. When you file a motion like this in court, you have to file a brief with it, basically supporting documents that show the court why it applies in this specific situation, yada, yada, yada. So, in that vein, I'm not going to address the Denny motion itself. I'm going to address some shit that was included with the Denny motion filed by Kratz, the brief that he put together. And that's this. When you file a motion like this, you have to cite other cases that show specific evidence of why this applies in this specific situation. So, with that said, let's plunge right on in there, shall we? And Kratz, darling Kratz, Wilbur, I would like to thank you since now for doing all of my research for me on this. You're so sweet. So, in Holmes versus South Carolina, which is one of the cases that he cited in his brief, whether rooted directly in the Due Process Clause of the 14th Amendment or in the Compulsory Process or Confrontation Clauses of the 6th Amendment, the Constitution guarantees criminal defendants meaningful opportunity to present a complete defense. That didn't happen in this case. And it didn't happen in this case because of the fucking Denny motion. It is complete bullshit. And right there, that alone should guarantee Stephen Avery and Brendan Dassey a new fucking trial. I'm just saying. However, it gets better. While the Constitution thus prohibits the exclusion of defense evidence under rules that serve no legitimate purpose and that are disproportionate to the ends that they are asserted to promote, well-established rules of evidence permit trial judges to exclude evidence if its probative value is outweighed by certain other factors, such as unfair prejudice, confusion of the issues, or potential to mislead the jury. Judge Willis did nothing but exclude pertinent evidence simply because of this stupid fucking motion, and not because it was going to cloud the issue. It was precisely because it would uncloud the fucking issue. That is where I'm having a problem. But it gets better. An application of this principle is found in rules regulating the admission of evidence proffered by criminal defendants to show that someone else committed the crime with which they are charged. Such rules are widely accepted and are not challenged here. In Gregory versus South Carolina, the South Carolina Supreme Court adopted and applied a rule intended to be of this type. This case, however, the court radically changed and extended the Gregory rule by holding that where there is strong evidence of a defendant's guilt, especially strong forensic evidence, proffered evidence about a third party's alleged guilt may or perhaps must be excluded. Here's the problem, though, folks. The forensic evidence in this case was not strong at all. Kratz himself has even said that he knew he was running a completely circumstantial forensic case. It gets better, though, believe it or not. The critical inquiry concerns the strength of the prosecution's case. If the prosecution's case is strong enough, the evidence of third-party guilt is excluded, even if that evidence, if viewed independently, would have great probative value, and even if it would not pose an undue risk of harassment, prejudice, or confusion of the issues. Are you shitting me? But this is the part that's really going to twist your titties. Furthermore, as applied below, the rule seems to call for little, if any, examination of the credibility of the prosecution's witnesses or the reliability of its evidence. So basically, this fucking brief right here says, if there is strong enough forensic evidence, we're not really going to look too hard at how fucking credible the evidence or the witnesses of the prosecution are. You've got to be fucking kidding me with this shit, folks. The rule seems to call for little, if any, examination of the credibility of the prosecution's witnesses or the reliability of the evidence. Then what the fuck are we having a trial for? By evaluating the strength of only one party's evidence, no logical conclusion can be reached regarding the strength of contrary evidence offered by the other side to rebut or cast doubt. It's right there, right underneath it. It fucking contradicts itself. The fuck is going on up there in Wisconsin? All right, folks, so this next part of the brief, this is the part where I can understand a Denny motion coming into play. Okay, I'm going to go ahead and read this really quick so you can compare and contrast between this case and the Stephen Avery case. Okay? On the morning of December 31st, 1989, 86-year-old Mary Stewart was beaten, raped, and robbed in her home. She later died of complications stemming from her injuries. Petitioner was convicted by a South Carolina jury of murder, first-degree criminal sexual assault, first-degree burglary, and robbery, and he was sentenced to death. Upon state post-conviction review, however, Petitioner was granted a new trial. Get this shit. If this doesn't burn your fucking ass hairs, I don't know what will. At the second trial, the prosecution relied heavily on the following forensic evidence. The petitioner's palm print was found just above the doorknob on the interior side of the front door of the victim's house. Fibers consistent with a black sweatshirt owned by the petitioner were found on the victim's bed sheets. Matching blue fibers were found on the victim's pink nightgown and on petitioner's blue jeans. Microscopically consistent fibers were found on the pink nightgown and on petitioner's underwear. Petitioner's underwear contained a mixture of DNA from two individuals, basically the victim's and his. And petitioner's tank top was found to contain a mixture of petitioner's blood and the victim's blood. That's a strong forensic case right there. That's fucking open and shut, folks. That's do not pass go, do not collect $200. As a major part of his defense, petitioner attempted to undermine the state's forensic evidence by suggesting that it had been contaminated and that certain law enforcement officers had engaged in a plot to frame him. Petitioner's expert witnesses criticized the procedures used by the police in handling the fiber and DNA evidence and in collecting the fingerprint evidence. Another defense expert provided testimony that petitioner cited as supporting his claim that the palm print had been planted by police. Okay, folks, in that case, I can totally understand citing the Denny motion and bringing that shit into play. But if you take the fact that a vial of Stephen Avery's blood was tampered with, we know it was tampered with, all of us have figured that out, okay? As a result of the fact that that was there, the blood evidence needs to be excluded. So exit that shit out of there. All right? Now let's look at the key. The only other piece of forensic evidence that could possibly tie Stephen Avery to Teresa Halbach. It wasn't found until the 7th fucking search, and it was found after the police had already had the fucking use of the property completely free range for a number of days prior to its being found. Therefore, that evidence must be excluded because it's suspect. Other than that, what the fuck did the prosecution have? Oh, well, her car was found on the property. Yeah, whoop-de shit, it was a fucking salvage yard. Okay? Where the fuck would you hide a car that you were trying to get rid of? A salvage yard is a perfect dump site for a fucking car. Hello? So basically, folks, this Denny motion, here's what a lot of people don't understand about it. That Denny motion was filed before the fucking trial even started. As a result of that Denny motion, there was a whole lot of shit about this case, about the defense's case, that the jury did not hear. They didn't hear it. And any time that anything came up that Kratz didn't like, he would object, citing the Denny motion, and it was then excluded 9 times out of 10 outside of the jury's hearing. They're able to tell the jury, we need you to leave the courtroom for a minute. And they did a lot over the course of that fucking trial. So the jury never fucking heard it. They never saw it. Ever. Not once. That is why the fucking jury convicted him. Is because Kratz made good and goddamn sure that they didn't hear anything other than Stephen did it. You just need to decide to what degree. That's it. That's all they heard. They never heard any of the evidence that could have pointed to the fact that somebody other than Stephen Avery could have been responsible for it. That's what I want you to remember. Keep that shit in the back of your head as we go forward with the rest of this case, okay? Now, I have got a fantastic announcement for everybody. My business partner, John, and I have decided to start Get a Clue TV. What this will be is a web channel, which will, for $5 a month, give you complete access to wall-to-wall coverage of not just the Stephen Avery case, but several other cases of its kind. But in order to start this channel, John and I need capital. So we have started a Kickstarter campaign. I'm going to go ahead and include that link down below in the description. Don't forget to go to Facebook, go to hashtag Justice for Bryant. You'll read all about yet another young man that was railroaded by the state of Wisconsin, just like Brendan Dassey was. Don't forget to subscribe to me on YouTube. Don't forget to follow me on Twitter, MamaPhoenix6. And don't forget that if you'd like some really cool fan merch, you can go to my channel page, click the little green t-shirt in the upper right-hand corner, and that'll take you to my fan merch store. Thank you all very much for watching. We'll see you soon.